The other witnesses would kindly come to the table. Ms. Guy, Chief Executive of Citizens Advice, Ms. Bishop, Director of the Law Centres Federation, and Mr. Newdick from the National Pro Bono Centre. Welcome. We're very glad to have your help with our inquiry. And I'm going to ask Mr. Turner if you would begin.
Thank you very much, Chairman. Just very generally, I suppose, the government is saying that legal aid must be cut, and that it facilitates, as it stands, more unnecessary litigation. Generally, what would you say about that?
I think there are issues that have to be dealt with around the legal aid budget. We don't deny that because of the way it's grown over the years. But the issue with regard to where the cuts will fall is that early intervention and advice will cease to be given. And that's very often the advice that stops matters going into litigation. And therefore there could be further costs as a result of stopping that early intervention as things go into court.
It seems to me that the CAB have received a triple whammy. Legal aid cuts, both in relation to scope and a real terms cut, local authority cuts, and the elimination of the Social Inclusion Fund. What would you say about the implications of put it crudely, getting rid of the Social Inclusion Fund? How does that affect the CAB?
Well, the principal issues we have through the Bureau are that there are three, as you rightly say, three areas of cut coming our way. And the difficulty is that they're seen in isolation, and of course they have a cumulative impact. One of those is the legal aid, which is tantamount to 15% away from our Bureau. Another of those is local authority funding, which at the moment we don't have a full picture of. We only know about half of the local authorities for our Bureau. But it's looking at the moment like an average of 10%, but it goes as high as 100%. And then we have the Financial Inclusion Fund, which itself is another almost 20 million, and together, all of those cumulatively could impact to the tune of 45% on our Bureau. And that's quite devastating in terms of the kind of advice that we can sustain when there is increasing demand.
I think at the moment you've got something like 400 bureaus nationwide. Am I correct about that?
Just under, yes.
Just under. How many do you see surviving following the implementation of these proposals?
That's a very difficult thing to predict because not all local authorities, for example, have yet decided on their budgets and their grant funding. So we've heard from about half at the moment. As I say, our average is about 10%. On its own, that wouldn't close down Bureau, but when it gets as high as 100%, then the sustainability of the Bureau is gone. And there are a couple of cases already where we're having to close our doors to people's general advice.
Yes. I think you've touched upon in your answer to an earlier question the early intervention. How important is that? And would I be right to suggest that it actually saves money long term?
It is certainly in our evidence, because we've done some research on this, that for every pound that is spent in that early intervention and advice, we can save the state generally between about £2 and £9. And that's based on the data that is given on performance to the Legal Services Commission on positive outcomes, and then the work that's done by research on what are the adverse impacts of cases not being resolved at that stage and going on into court. So if we extrapolate those two things and multiply them up, we can come to that figure quite robustly as a saving to the state as a result of early intervention.
Right. So the proposals at the moment, you say, are not correct?
I'd say they're a false economy.
Okay, thank you. In relation to law centres, How many law centres do you see surviving? I think there's 56 nationwide at the moment.
Yeah. My answer would be fairly similar to Gillian in that we don't know the full extent of local council cuts, but I have prepared today, and I can leave this behind, the impact of the funding cuts on law centres right now, the announced cuts. And so the announced cuts from the legal aid budget, and that's before you factor in the telephone gateway of 55% of law centre funding, out of a budget of 8 million, over 5 million will go. That's the announced scope cuts. But if you add in the impact of the telephone gateway, where it's foreseen that 80% of clients will go through that gateway and may not reach the remaining of what's left in scope, it could be almost 90% of that funding. In terms of the multiplier effect, law centres receive over 30% of their funding from local authorities. Similarly, that changes around the country, but we estimate more than that because many law centres have already been notified of their loss. So Hammersmith and Fulham, for instance, has already lost 180,000, which is the full amount of their local authority funding. We also have another 10% of funding from other government departments, many of which are also cutting. So we get 19% of funding from charitable sources and philanthropic. So we estimate that we will be left nationwide with a maximum of 30% of our funding. How we continue services with that is something that we're working on now. However, it must have a significant impact to lose all but 30% of your funding. In relation to your previous question about unnecessary litigation, I think the important thing, and one of the themes that ran through the Green Paper, was a view of the client that uses legal aid. And that may be an average client, but my understanding is that the LSC nor the MOJ currently collects data really on the nature of client and client disadvantage. They have certain demographic data, but it doesn't give you a complete picture. So, for example, you can mention one disability, but many of our clients have multiple disabilities. And as you know, there is a big difference between being deaf and blind to just being deaf. So these are significant absences. My colleague from Nottingham mentioned our client profile, but again I can leave this with you. Our clients are poor, they have lower than average educational attainment, they have poor literacy and numeracy, they come from non-English speaking backgrounds, they have a higher than average rate of disability. We have a higher than average number of legal aid clients who are under 25 because we have specialist youth services. Almost 60% of women. Importantly, 45% of our clients only have access to pay-as-you-go mobile phones. Most do not use the internet to access goods and services, and many of them have substance abuse, mental health problems, lead chaotic lives. Now, I mention that because you're talking about unnecessary litigation. Our clients are not the people who just want a few hundred extra pounds because they tripped over the gutter. We are talking about a very different kind of person.
You've talked about the type of client. What type of cases would you be involved with?
Law centres cover the full range of legal aid. We, with the exception of criminal legal aid, as you know, it was through law centres' work that the police, legal assistance at police stations began, but we've since passed that on. We have a couple of law centres that do family law, but in general we do mental health, community care, welfare benefits, debt, immigration, asylum, public law, all the areas that are currently funded in civil legal aid. What are the proportion? I think the proportion of our work is indicated in the amount that's lost. Our biggest area of work currently is housing, employment, immigration. Immigration and asylum is second to housing, then welfare benefits.
Mr. Newdick, did you want to talk about anything like that?
Yeah, if there is an assumption that somebody or some bodies will step into the breach and fill this what looks to be an enormous gaping hole that's going to be created when no social welfare law, legal aid provision will be provided. And if there is an assumption that that will be by lawyers doing more pro bono work, I have to disabuse you of that, I'm afraid.
We'll come back to that issue a little later in our questioning, if we may, much more specifically.
That was about to be my next question, really. You don't foresee pro bono practitioners taking up the slack, then?
They can't. The way that pro bono works in giving assistance to individuals is based on a very close relationship with the frontline advice agencies that are sat to my right. Pro bono doesn't just happen in a vacuum. We, as a charity that have been trying to provide this infrastructure for the last dozen years or so, we recognise that the people who know best about where the need is and where it should be, there's legal help is best provided, are the voluntary sector organisations. They have become increasingly dependent on legal aid funding for their survival. If they don't survive, pro bono won't survive, because lawyers require or demand a level of administration and service if they're going to give their time for free. And that's what LawWorks does. We've put that infrastructure in place. But the service is provided through the advice agencies, through clinics which operate usually in the evenings but often at other times of the day with volunteer lawyers. And if there is no clinic, the lawyers won't do it. And I do need to tell you that the sorts of lawyers who get involved in pro bono have lots of other enticing areas of pro bono activity they could get involved in, often international, saving the world or other people in other jurisdictions. This is not the most glamorous end of pro bono provision, but it's one that LawWorks feels fundamentally that we need to find lawyers who are willing to provide that service, but they can only provide it if there is an infrastructure within which to deliver.
So, what will happen to these clients then? Does it ultimately mean that the system is likely to collapse? Where they're going to go?
There will be nowhere for them to go, in my view. If CABs close and law centres close, where else are they going to get assistance? I think MP surgeries is probably going to have very large queues outside going forward, because what else is there left? I mean, private practice law firms, which of course are the ones that are providing the pro bono assistance, are not going to allow these people through their own doors. They do this as an adjunct to their normal daily activity, so I don't think there'll be anywhere for them to go.
Jane Elizabeth Truss.
Thank you. In the last session, we heard about some of the cost drivers of legal aid spending. Given that we do have the highest legal aid bill per capita, I think, in the world, I'm just interested to know, you've talked about the majority of people that access services tend to have chaotic lifestyles, low educational background. Do you think the main driver of legal aid expenditure here is social issues, or what are the drivers within the legal system itself for what's making our legal aid bill so high? And the third part of my question is, what would you do, both outside the legal budget itself and within the Ministry of Justice budget, to reduce that bill?
Just going to say that there are several drivers, and I think to aim first and foremost at the early intervention and advice, as I've said before, is a false economy because it brings its own costs. But one of the drivers, for example, are high-cost cases where they take an inordinate amount of court time, and I think the court process really does need to be looked at, which is another part of the Ministry of Justice. There are administration savings, I think, to be had in the legal process generally, particularly criminal, where a lot of the legal aid budget does go. There's an enormous amount, and any of us who have been on the receiving end of this can testify to it, of bureaucracy around the way in which legal aid is administered currently, and there is much, I think there was 350 million accounted for last year, that could actually be taken out. There are perverse incentives in the system to go forward to litigation. There are incentives for lawyers to take court proceedings in order to get certificated clients, and that doesn't help in the backlog that goes through the court process. And I think there's also probably insufficient preparation of any alternative disputes provision, because it is right that there are alternatives to court, but they're not necessarily available right now, and therefore ought to be put in place before early intervention is looked at.
And do you see that happening in other countries? Are we sort of behind the international curve on this?
I think we're different to the way other countries deal with it, and it is often said to us, well, we are the most generous in terms of our legal aid budget. The fact that it's not cleverly administered, though, is not an excuse or shouldn't cloak that. I think we should look at it for how we are and perhaps learn from other countries in the way it is administered. But certainly alternative disputes are much more successfully handled elsewhere.
In terms of In terms of the cost drivers, I think, again, my colleague from Nottingham mentioned that 42% of clients who walk through our door are the result of errors elsewhere. But I think we need to elaborate on that a little more and say that in December 2010, the National Audit Office found that DWP had made no improvement in their error rate since 2007. So when we're looking at cost drivers, it seems not the correct place to look at the victims of those errors that are happening elsewhere. And so many of the cost drivers are outside of the department. But in terms of what will we do to make it different, the other point to make is that social welfare law, the law of the people that we represent, which we call the law of everyday life, or rather in most other countries they call poverty law, is a very small part of the legal aid budget, and yet it represents, I think it's 274 million of the proposed 350 million cuts. And we believe that if you are going to cut, you don't focus on the poor for 70% of the cuts. However, what could you do? Well, an obvious thing is there appears to be, as Gillian just said, looking at alternate dispute resolution, or looking at maybe tightening the benefits test, the merits test, I don't mean the benefits test, the merits test to maybe include whether or not a person is able to represent themselves. And there's probably other ways to actually tighten the merits if you want to try and ration legal aid rather than removing whole areas of it. That's one thing. And then the third thing to say is even if you want to take away 500 million from legal aid, you're still left with 1.6 billion. I think that you must be able to have a legal aid system that includes civil legal aid and legal assistance for the poorest, most vulnerable members of the community once you have 1.6 billion. And the other problem in relation to that is that the rationale for the cuts being projected has been in relation to how much can we cut of A, B, C, D. Yet nowhere within that document is anything talking about what works for the client. How can we design a system that will actually produce benefits for society as opposed to just cutting spending? So I think with 1.6 billion it will be possible to reshape a legal system, not through the lens of cutting, but through the lens of a client that still allows some of that 1.6 billion to be spent on the poor.
So what specific suggestions would you have about how the process could be streamlined at the same time as reducing the bill? Because clearly it's not delivering efficiently, is it, if you look in comparison to what's being delivered elsewhere? And although I do think Britain does have a particular social issue, and we do have low educational attainment is a problem here, but I'm sure there are issues within the legal system that could be.
The LSRC conference in June last year, a paper was presented by someone from Holland that was very interesting, and I could get you the citation, but it talked about the most effective way to spend €1,000 in relation to achieving access to justice. And the result of that was that the €1,000 were best spent in simplifying court processes, and it was across Europe study. So I think, again, previously someone mentioned court processes, so that's one mechanism for streaming. And again, one of the cost drivers for representing clients is completely out of their control. If you take immigration, the Home Office can take years upon years before they settle the case, and so there are inherent costs involved in keeping that matter open over that 7-year period. So once again, the cost drivers for the poor, the people we're representing, are completely outside of our hands, and that streamlining must be done with view to the MOJ in its entirety.
Do you see the MOJ, because the MOJ say that that's what they are working on, do you see any signs of that? Or is it not radical enough? I mean,
I think that many of the cuts within the Green Paper will actually increase MOJ costs. So, for instance...
No, sorry, I was asking you specifically about the streamlining of court processes. Do you see signs that that is underway?
I think in terms of costs, there's the family law review that's happening presently that could well lead to a lowering of costs, and indeed we'd ask the question of why you're proposing costs before you know the solution. I would suggest that in family law there are many efficiencies and even better ways of resolving family disputes than that actually happen now that are quite costly, and one would assume some of those will come out of the review of family law.
I think the streamlining of processes isn't going to help people who don't understand how to operate the system in the first place. And the idea that people will manage on their own without any assistance...
That's not what I'm saying. I'm saying that if you were to propose alternative ways of making savings in the MOJ budget, how would you do it? And if streamlining is one of those, what would that mean?
There is an area in terms of access through both telephone and electronic means which I think can streamline and save costs, but it does require some joint working. It requires the voluntary sector and government and the pro bono sector to work together to try and achieve that. And so far we have managed to do that with the Ministry of Justice, and we would like to do so. So that there are ways of streamlining which will save costs.
I'm interested, Mr. Newdick, whether he thought that courts and particularly tribunals could do more to make it feasible for people to represent themselves by taking a more inquisitorial approach and making it clear to the people in front of them what information it is they need to provide.
I think, as a practitioner, because I'm a practicing lawyer, aside from my role as chairman of LawWorks, I think the amount of regulation and the complexity of law which faces most citizens, I think is very, very difficult for a tribunal to suddenly make it simple and easy for them. One only has to read an employment tribunal decision to see the complexity of it. So I don't think the tribunals themselves are going to help simplify issues. I think they could intervene in terms of trying to get earlier resolution of disputes, and certainly in mediation, which is not a topic we've touched on yet, but in terms of early intervention and resolution, I think there is something there that could be invested in, which could achieve more savings in terms of court time.
Claire,
forgive me, if I might just focus some questions to Ms Guy, because I'd like to pay tribute to the work the CAB does. It's an enormous resource across the country, and I'm very concerned because I think there is a perception that you are the people who will, be stepping up, if you like, to use your language, Ms Newick, to take some of this responsibility.
I just defer you in that case,
yes,
because we have a group of questions about CAB, and I'd rather take them.
Fine, then I will hold. Yes, of course.
And perhaps Yasmin Qureshi had a question on what we...
Mine was in relation to the suggestion about whether the tribunal members could help in the resolution process. Is it fair to say most of these tribunals tend to have lay people as sort of the adjudicators, welfare and disability tribunals?
Well, my own personal experience is within employment tribunals where the chair, the employment judge is legally qualified. I had understood most tribunals have a legally qualified person on the panel. It's not just lay people.
Yeah, I think one of the other things in terms of
Order. Bishop.
in terms of tribunals, 60% of people who are represented at tribunal do reach a settlement. That's ACAS figures. So I think if we're talking about streamlined processes, you could argue that representation actually decreases costs. The second thing to say in relation to that is an issue of equality of arms. Our people may go along, even if they're not represented, a law centre will have prepared witness statements, assisted them with, working out their cross-examination, etc. But we have not had one case of an employer that is not represented by a barrister. I cannot give you a case. And prior to this, I bothered to try and find out. It could be one, but nobody could present one. So I think the issue really here is not about lay people and how simple the system is, but does the British justice system believe in equality of arms? Does this Green Paper seek to destroy equality before the law? Is this what we're up to? And if you're saying that the majority of people are able to represent themselves, well, say that to the employers, say it to the DWP, say it to the Home Office. Don't just say it to us.
Yes, Ms Guy, looking at your submission here, your evidence states that for every £1 of legal aid expenditure on advice, somewhere between £2 and £9 is potentially saved to the state. Can you explain how these figures were calculated, please?
I can certainly give you our methodology. I referred to it slightly earlier. The first thing we took were the Legal Services Commission outcomes data that they require as part of their performance management of the contracts. So we then get an understanding of where there are positive outcomes to the legal help that's given and where there are not positive outcomes, so that either disappears or goes into the court process. We then took the Legal Services Research Centre research, which looked at the adverse consequences and costs of those cases that did not reach and would not reach positive outcomes, took those two and put them together through an economic model which looked at the kind of costs in terms of housing, in terms of health that ensue, and indeed court cases that ensue as a result of that early advice not being successful, and then multiplied that up. And that gave us a figure of a £1 investment bringing forth between £2 and £9 saving to the state.
The Green Paper says that less costly alternatives need to be found to using lawyers and the court system. What do you envisage those alternative options would be?
I think the alternative options do rest on the kind of alternative disputes that we've been talking about, disputes resolution and also mediation and those things. We wouldn't be advocating that the alternative is litigants in person for the reasons that my colleagues have just expounded, really. We think that actually adds to costs in the system because it takes longer for a case to go forward, and we do think there's inequality bound up in that. So I think it would be about looking at alternative methods. I've already spoken about the way of taking costs out of the system, and just to hark back to an earlier question, one of the reasons that costs don't come out of the legal system is that it is not one system. It's a variety of systems with too many vested interests in it, and actually what it needs is a cohesive review that brings some savings out, and that's the only way to get streamlining.
I'm looking at your submission again. On point 9, you says you publish a table there. And you've got a category. You said this table clearly shows that the proposals, as well as reducing the volume of publicly funded cases overall, will shift the balance of public funding away from early advice. How important is early advice in reducing costs, and do you think the MOJ is missing a trick here?
Well, the figures that have been given by the MOJ vary, which is unnerving, but the figure that we've taken is that 97% of the early advice will be hit. So 97% of that intervention will be hit, which is in organisations like those represented before you today. Obviously, the cost that we see arising from that is that £1 has gone, and therefore the saving of between 2 and 9 has gone for every one of those pounds, and that amounts to a large loss of saving.
Have you made any estimate of the amount of cases that won't be resolved at all if these proposals went through?
Well, there'll be those people who have nowhere else to turn, and it's the point made earlier, really.
I
If
like
the
that
advisors are not there, there is nowhere to go. They won't necessarily suddenly find the wherewithal to go and represent themselves in court. They won't find the wherewithal to go and get legal advice. They may find that they are cornered into going, particularly in terms of debt, into debt management agencies, where we know that people are very often exploited as a result of that, and some 40%, for example, of any recovery that happens in benefits is taken away from them by those agencies. And I'd rather, as an organisation, not leave them to those kind of devices, but actually offer them advice that enables them to get the benefits to which they're entitled.
So, I know it's outside the scope, but some of interest is financial inclusion. Do you think doorstep money lenders are now going to thrive if these proposals went through?
I think the difficulty is when people are vulnerable, they can be taken advantage of. And when other people have a commercial interest in doing that, it's going to happen. What we like to do is be able to prevent that and give advice and make that intervention, and that's what's under threat at the moment.
Yes, and thank you. To just continue where I was going with the CAB analysis, I was interested, you polled off about 100 bureau, which is a relatively small percentage of your 3,300 outlets, and specifically on the 15% withdrawal of funding, the legal services funding. And that there was quite in a way, a disproportionate response, that 51% of the bureaus you polled said that there would be a risk to their continuation as a result of that. Do you feel that would be represented across the whole picture if you polled all of your outlets, or do you think that was perhaps disproportionate based on those who were responding?
I think we have to compare the right figures, first of all. It's not 100 out of 3,000 plus.
Right.
It's 100 out of just under 400. So that's a quarter of our population of bureaus, because the outlets obviously are multipliers of the bureaus. So that's the first thing. That's about a quarter. Those figures were about legal aid expenditure and the impact on those bureaux of that.
It was the 15% of the national budget.
Exactly so. And that isn't equally spread across the bureau. So it wouldn't be all 400 that are impacted anyway. So it's 100 out of an even smaller figure than that. The next point that I made earlier is there's a cumulative impact on those bureaux as well.
Yes.
Because in terms of financial inclusion funding, 19 million is under threat currently to go by the end of March, and over 300 workers are currently serving their redundancy notice out, and they will go, that specialist advice will go. There is also the local authority funding, on average, as I say, 10%, and we've seen some of the impact of that, but it does mean that some of the general advice won't be there as a backup either.
And you referenced, I think, if I may add, that the overall picture was looking rather worrying, if it's a 40% reduction if you add up all of these various reductions. When was the last time your budget was that small, if you like? Where would that take funding back to relative to your history?
I said 45%. I don't actually have a date. I can't say that. If there's a point you want me to address.
I suppose what I'm trying to understand is, because I don't know the numbers. I mean, a hypothesis might be that, for example, the national inclusion, the financial inclusion money, which I think is actually a very good project, is a relatively recent addition to the CAB budget. I suspect, like all budgets, there has been quite a lot of inflation, if you like, of these budgets over the last decade, 20 years. And what I'm trying to understand is, within the picture of looking back historically, what did the CAB do with what amount of money 5 years ago, 10 years ago? Because what we're trying to understand is how resilient is this fantastic service? What is the leverage in the service for getting in volunteer caseworkers, people who can assist, so that when we actually make a submission, we can actually understand what is the likely outcome as opposed to the Armageddon outcome, which none of us would want. So whether you're able to provide numbers that look at this budget relative to your historical data or not, that would be extremely helpful to know, relative to your historical picture, what this budget cut might look like. Might you be able to supply that to the committee?
You're most welcome to let us have that information later.
Yes.
Yeah, I'd be very happy to provide that information. What I'd like to add to that information is the increase in demand for the service that we provide. And actually the pockets of money that you are referring to quite rightly, such as the Financial Inclusion Fund, came out of another change in circumstances, which was a recession, and the need for 70,000 people every year through that financial inclusion fund to come just to CAB for advice on their debt management, because they're getting into situations where they'll be homeless, be repossessed, and have to move their children from schools and such like. So those specific issues have changed historically.
I do understand that, but my understanding was the financial inclusion fund became policy prior to the 07. It was certainly on the policy mix prior to the 07 recession. And again, one of the issues we have, I think, within the committee is, what is it that has changed so fundamentally about Britain? Is it the complexity of benefit law? Is it the social issues that my colleagues mentioned? What is it that is so unbelievably complicated that we now need to be spending more money to tackle the problems? Because clearly we'd like to tackle the source rather than the cause rather than the symptom. I think is we would all probably.
And I think it's all of those things.
Right.
And actually, as citizens' advice movement, if you like, what we're trying to do is tackle the benefits system to try and take that out of its complication.
I know you support the simplification.
We do indeed, and we're working with government to try and make sure it works first time, as opposed to picking up problems later, because it would suit our purposes if people didn't need as much advice.
Absolutely.
But the situation we're in is that they do, and until those steps are taken, what we don't want to do is withdraw the advice.
I understand. Thank you.
Okay.
And just finally, if the MOD has its way, a number of areas which currently receive legal aid will be taken away. How do you feel? Are there current systems in place or places which could step in and actually do the work that other centres used to do? So is there viable alternatives at all in the system for those areas of law which are going to be no longer legally funded?
I don't think there are free alternatives, and I think that, in a sense, is the conundrum that we're in. The fact that something comes out of legal aid expenditure and is no longer financed means that either some other department has to pick it up as a social issue, or it doesn't get picked up at all, because the alternative for these people is not, I would submit, to go and pay for legal advice, because that's what led them into the situation in the first place. They also value, I would say, independent advice. And I know that the Green Paper talks about things like Job Centre Plus being able to give advice. Well, apart from the fact they're not in the business of doing so because they give information, they're not necessarily the first place that people trust when they're looking for that advice. And I've not noticed that any extra money is going into Job Centre Plus to enable them to do that. So I think the conundrum is that it's not free. Volunteers aren't free. So we could double our volunteer workforce by campaigning for volunteers to come forward, and we're very lucky that they haven't all drifted away. But we have to pay to manage that, to supervise that, to make sure that they are trained, and to make sure that they have the information that people can rely on. So I don't think there is a free place to go.
Yeah. And just to add to what Gillian said, in the past government has contracted with agencies like ours because we provide more than just the pound that you get. As Gillian said, they've done some costings. We also commissioned a savings document a couple of years back where we found that for every pound spent at a law centre resulted in £10 of additional benefits. But the point I'm trying to make is that when a client comes to a law centre or a CAB, we are dealing with their legal problem, but we're part of our local community. They come to us mostly because their neighbour or someone else has said, come here. They're not people who look up the internet and say, oh, I'll find my law centre. Someone, a community member or a relative has brought them to us. And so we are then able not just to address their legal problem, but to plug them in to other support mechanisms that can help them in their life. And at a time when there are major changes happening across government, across policy program, and that at the heart of a lot of that is about personal responsibility and self-reliance. Often they need to start somewhere. They need to start at a trusted organisation, and so we may be dealing with a legal problem, but in fact we're a key part of that path to people getting back onto self-reliance, being responsible for themselves, being plugged more effectively into their local community and into other supports. So we would argue in taking away a cost saving for a legal matter, you're actually taking away a lot else. You're taking away all our connections You're taking away all the other money we leverage at law centres, for instance. Clearly, we're madly thinking at the moment, how do we survive these cuts? We're in talks with everyone, but I need to tell you
on that point, so in talks with everyone, have any of your organisations had any discussions with government departments, not just the Ministry of Justice, but the Cabinet Office, or indeed the departments that generate the problems, like the DWP, for example? Have any of you had approaches or been in talks with them about what happens if all this goes through?
Well, not in relation to specifically to the Green Paper, but as Lawworks has lost its funding from the Ministry of Justice, we have been attempting to talk to the departments in relation to the work that we do, and so far we've had no positive response at all. Could I just comment on what will be left? I think what we're talking about here is a dismantling of an infrastructure which has fantastic leverage. And you lose all of that if the infrastructure goes. Because we talk about people who do this sort of work because they're very committed to it and they give more than their job's worth in terms of the work that they do. But also they can leverage to obtain a massive amount of free legal advice which would not otherwise be available. So through Lawworks we deliver something like 40,000 pieces of advice a year. But we have to do it within the infrastructure because there is no other way of delivering that. And that will go at a strike. And there are many other instances of where the infrastructure disappearing will mean that there is no ability to leverage off other help and assistance which is free.
Could I?
Sorry, who was... yes, sorry.
Just wanted to come back on your question, Sir Alan. It was really... we have had talks with other departments because, as members of the committee may know, as an organisation, we wanted to do that as soon as the comprehensive spending review was really thought of, to try and get some cohesion, really, for how that would impact on people, particularly our clients. And I would say that we've had open ears to talk about things, and we've talked about the reform of the benefits system, and I think we've been welcomed in terms of giving some input to that. So the difficulty, I think, is actually in getting departments to talk to one another, not necessarily to us, because there is a holistic approach required here to save, in terms of early intervention, to save those problems arising in the first place. We as an organisation are trying to get into prevention as well as cure, and I think the government will be well placed to try and do some of that as well. I can understand an argument that actually says this isn't just the MOJ's issue. I have some empathy with the argument that says, well, if we're going to sort out legal aid, there may be that this is a social issue that needs to be picked up somewhere else. But that somewhere else has to be identified, and that is a government-wide responsibility.
Mr. Turner.
Thank you very much, Chairman. Just finally, really, I suppose, would it be an outrageous, over-the-top suggestion for me to make that collectively you're fearful that the system really, really will collapse if these proposals go ahead? Is that outrageous or not?
You call the leading question, but
yes.
Have a go.
It's very tempting to say
it already is. Obviously, we've seen... there's talk about how is it all costing so much, but we've got to remember that civil legal aid has actually gone down. Legal aid bill goes up, but it's because of criminal legal aid. Civil legal aid has gone down. And I've seen several law centres who've had huge difficulties as a result of the way that the funding or the payment through the LSC has been made. And there are many who have already closed, and there are some that are very much on the brink of closure, even with the funding as it is now. So I don't think there's any doubt that this will disappear as a service if these cuts take place.
You said earlier that you were looking at for every possible way of surviving.
We are, indeed. I think law centres commenced 40 years ago because this service wasn't available. They were helping people who were working with unscrupulous landlords, and indeed there'll be this need again if these cuts come through. So I think when I was saying we were talking everywhere, we were of course talking to law firms, to other philanthropic agencies, to just work out to what extent is it possible to go back 40 years, what will be left for us to do, what sort of service are we going to be looking at. And I would suggest that some law centres will certainly survive, but they won't be picking up what I would regard as government's responsibility to serve the poor will be a stopgap measure. We won't have the impact that we have now. But there was a question earlier about costs as well, and I think something I just wanted to add to that. An example of costs within MOJ is that education at a cost of $1 million is seen as coming out of scope. But every young person who is excluded from school, one young person costs £68,000 to government costs. But more importantly, MOJ, 72% of prisoners have been excluded from school, and only a very small, less than 10% of students are excluded from school. So that saving of $1 million within MOJ itself is going to have dramatic costs within MOJ. So there are these areas that we're looking at, that we're representing, we believe are actually a wanton waste of government money. We don't believe it's a way to streamline. We actually think that it will cause greater rises in costs within MOJ.
And CAV?
Well, just going back to whether a question is outrageous or not, I mean, we are not in the business of shroud waving and saying that citizens' advice movement is about to go completely out of existence, because we will fight tooth and nail to retain it because of its importance in the social fabric. And I hope that people will join with us in doing that and have some confidence in that. But I think there are some unforeseen consequences here, some impacts that really, I've termed them false economies, that really need to be looked at, and looked at very seriously before it's too late, because the costs will come down the track. And we appreciate, as I think a responsible organisation, that there's a deficit to be dealt with. We appreciate that there are cuts to be made. But just looking at the cumulative impact of those and the costs that they will generate really seems to us to be very important indeed. And remembering that the cumulative impact seems to be hitting the same group of people time and time again. So their situation will worsen. And we think our demand will increase and continue to increase as a result of that.
Thank you very much to the three of you. I think the committee is very appreciative of the valuable evidence we've had this morning. So many thanks. Order.
I raise a point about future witnesses. Can we interview some academics who understand the international comparison?
Coming in yet.
Because I just feel we need more of an overview.
Committee Room 5.